guys on? Teresa? Bob?
Good
You guys on?
Yep. Good to go.
Okay, I'll call the meeting to order. This is the Genoa Township Board of Zoning Appeals. It is July 23rd, 2024, and it is 7 p.m. We are at the Genoa Township Hall, located at 5111 South Old 3C Highway in Westerville, 43082. We have three agenda items tonight: BZA case 2024-06, which is a conditional use permit for 4986 Hawthorne Valley Drive. We have a BZA case 2024-10, which is an administrative appeal. And then we have BZA case 2024-11, which is an area variance for 7795 Early Meadow Road. Staff present is Susan Dorsch, Paul Benson, and Mark Fowler from the Delaware County Prosecutor's Office. And I will call the roll. Ms. Yu? Here. Mr. Phillips?
Here.
Mr. Hanson is absent. Mr. DeRose?
Here.
Mr. Christian?
Here.
And Mr. Campanella? Here. Excellent. Okay, I'm going to read the following statement into the record so everyone is aware. As is the adopted policy of the Board of Zoning Appeals, all applicants will be granted an opportunity to make their formal presentation. The audience will then be granted an opportunity to comment, followed by questions from the board. This policy was adopted by the Board of Zoning Appeals to provide for the orderly discussion of business scheduled for consideration. The chairperson, me, may limit repetitive debate. The first item that we need to take care of is the minutes from the prior meeting of June 25th, 2024. I'll give you a moment to look those over, and then I will entertain a motion to approve. Oh, okay, that's that. Okay, anybody want to make a motion?
Yeah, move to approve the board minutes from the June 25 meeting as presented.
Okay. Second by Mr. DeRose. Okay, any comments, discussion, revisions? All in favor of approval of the minutes from June 25th, signify by stating aye.
Aye.
Any opposed? Hearing none. Any abstentions? Okay, motion carries. Okay. Okay, we will go into our public hearings now, and I want to take care of one item on the agenda first. That's actually shown as the third item, which is, oh boy, Majid and Sophia Jolie requesting approval of a variance to construct an accessory building within the required 10-foot side setback at 7795 Early Meadow Road, Lot 5463 in Medallion Estates subdivision, Section 10, currently zoned planned residential. And this is BZA case 2024-11. And my understanding from staff is that this, is there anyone here appearing on that application? No? Okay. I understand from staff that the applicant has requested to withdraw the application. Is that?
You all have a copy of the email that we received.
I think we did see that, yes. And,
We received that on Thursday.
okay. Let's see. Oh, these are the Okay, so I don't know that we need to, does anyone have any discussion? If not, we can entertain a motion to withdraw.
Mr. Chairman, I would move that we withdraw the application, which was the '06 application, I believe, is that correct?
No, it's
Susan?
actually 2024-11.
Okay, -11. We move to accept the applicant's notice to us to withdraw their application.
Right.
Second.
Okay, thank you, Mr. Christian. That's based on the email we received on July 18th requesting to withdraw. Do we need to do anything else on that application, Susan? We're good? Okay. Oh, yeah, any discussion, anything? Nope. All in favor of accepting the withdrawal? I'll call the roll. Mr. Christian?
Yes.
Mr. DeRose?
Yes.
Mr. Phillips?
Yes.
Ms. Yu?
Yes.
Chair votes yes, so the application's been withdrawn. Then we'll move back to actually the first case on the agenda, which is, and I'll read the application into the record. Call this hearing to order at 7:05, and I'll read the legal notice into the record, and then I'll swear in any of those that wish to make any statements regarding the application, including the applicant. Anthony Lacco requesting approval of a conditional use to allow the construction of an accessory dwelling at 4986 Hawthorne Valley Drive, parcel number 317-322-02-047000, currently zoned suburban residential, SR. This is BZA case 2024-06, and this is continued from May 28th, 2024. We have the following items that have been entered into evidence, Exhibit A through E. I'll have those wishing to appear on this matter, please stand and raise your right hand. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Be seated. Okay. Okay, I think you're up, Ms. Dorsch.
Thank you, Mark. So as you noted, this is a continuance, and staff provided an updated staff memo for the board, and changes that were submitted by the applicant are highlighted in yellow. Staff did do some more research because the question came up of the one accessory building that was close to the house, whether it was part of the house.
Right.
And they did do some more research, and they did actually get a conditional use to use the accessory building as a dwelling while they were doing some extensive remodeling to the main house. And then it did state in that application that it would be connected to the main house. So you think that question is satisfied by the records that I found, that it is part of the main house? So,
Okay.
and it's compliant with setbacks and such.
Okay.
So that one was resolved. And then I also found a statement of agricultural exemption for the largest building on the
Right.
property, 42 by 50. So that one did have an agricultural exemption. I did not find any for any of the other buildings, but I did find for that one. And I also provided a spreadsheet of the
Oh, yes.
applications and the permits that were issued for the property that we located in our office.
Let's see. Is that, oh, that's this one. Okay.
Staff still having some questions to the number of buildings and the uses of the buildings. I'm counting that there's 9 accessory buildings on the property if you include the proposed one, 8 without the proposed one.
Mm-hmm.
And they list things a couple times. There seem to be treating one gazebo full house maybe as one structure, but the zoning resolution specifically states that anything that has a roof and 4 posts is considered a building. Plus, we don't have any permits on file for any of those objects or structures. There's also, we need to clarify for the record, because the applicant is using, I think, misusing the word dwelling sometimes, because it says the proposed barn will be the 5th dwelling.
Oh.
And I think maybe that one should have been
Probably.
maybe, I don't know, it was the 5th building or what, but it's a couple times it's stated as a dwelling, so that needs to be clarified by the
Yeah.
applicant when they
I'm sure they can clear
do
that
their
up.
presentation. And also, just for clarification for the record, the application states when they're stating that they comply with 1609.01, that it will not, the building will not exceed 12 feet in height. And just note for the record, on any lot over 3 acres, the maximum height is 35 feet, so they would not have to comply with the 12 foot. And accessory building is actually 22 feet.
Okay. Any questions for staff?
I'm not done.
Oh, I'm sorry. Just trying to move things along here.
Okay, the applicant states that that the plot plan shows a shelter house, and that this is a temporary tent and not a permanent structure, but we did not see any evidence to support that statement. And then once again, we have that statement that the barn is the proposed 5th dwelling. And I think there's some interchanging of words, like for accessory structure, accessory building, and dwelling, and it does get kind of confusing because accessory, everything could be an accessory structure, but not everything is an accessory building, and not everything is a dwelling. So there are distinctions, but I do understand that it can get confusing. Staff was unable to locate permits for most of the buildings shown on the site plan. We did receive that, or find that one agriculture exemption to the larger barn in 2017, but we didn't find any zoning permits for the other buildings, like the whole building and the other one they're calling a shelter house. We did not find zoning permits for those buildings. The applicant also provided pictures as part of their revision.
Oh, is that what's in here?
The pictures were not labeled, and we had a difficult time understanding and what the purpose of the photos were. And then after writing the staff memo, I did receive one phone call from a neighbor who saw the sign that we posted. They were just inquiring about what the request was. They didn't give any opinions, like for or against or anything. They were just curious. That's all I have.
Okay. Okey doke. Let's hear from the applicant. If you don't mind, you're going to go to the podium or stay there, either one, and just reintroduce yourself if you don't mind, counsel. Yeah, whatever
Could you
works.
push your button there for me?
Oh, yeah.
Thank you very much.
Thank you. Okay. I'm attorney Rebecca Skeels, and I'm here on behalf of LACO. Anthony LACO, as I previously stated, can't be here. He has a business in Costa Rica too, so he's there running it. And then his son Brett LACO is here on his behalf, and he actually is living on the property while he's out of town, so he can answer questions about use and specific things. I thought it was easiest, since there was questions from the last meeting and this, just to go through and answer questions first, and then hopefully I get those answered. and then you can ask more. Okay, so, the first thing we were gonna address, which you already mentioned, was the, principal dwelling is attached to the, she already touched on that, but it is attached to the carriage house. And that was requested as in the original permit, and we took, the pictures are just showing they are attached, and it also shows it's connected in the blueprints. Susan already addressed that. The, and I apologize, I know there was confusion on the accessory, building for the pool house and gazebo. I was confused too, because when I went to the property the first time, I didn't go back in the pool area. I did go there Sunday. They actually are one, so I have, and I could pass this around. It's actually a little gazebo above the pool house. This was permitted, it's part of the blueprints for the addition. It was called the pavilion on the blueprints. This is included in that permit there.
Yeah, okay.
Yeah, I
I
can
don't
show
believe
you
it's
on there.
part of the zoning permit though, but
Okay.
we'd have to clarify that.
Yeah, it's in the blueprint. Okay, and then the accessory structure in question, I made it, I'm not sure what you will consider it, to be honest. I've read the rules. They bought this at Costco. It's temporary. It's, Brett and I can pick it up and move it. It just has these temporary hooks right here. It's out right now because his sister's getting married on the property in September, so they're getting ready, but it moves around. It's like one of those things you see, that it's, so that is, and these are all marked on here. Now, there was a question the last meeting about the agricultural exemption, and they do now have chickens on the property. We have pictures, the gazebo's being used, so all that we are claiming under the agricultural exemption, and then as well as the storage shed that's right across the thing, because there's an exterior photo and an interior. This is now housing the things they need to take care of, the animals that are back there. The proposed unit, that was a typo on the sheet. That would be the only accessory dwelling. There was an issue when we originally applied that carriage house was all right. I understand you can only have one. This will be the only dwelling. This is the location of it. There's a big barn here. That is an accessory building that's permitted. Then there's a wood shelter. I looked up Delaware County. I couldn't find specific in Genoa Township, but it says that any one-story detached accessory structure used as tool storage sheds, playhouses, similar uses, provided the floor area does not exceed 200 square feet and playground structures does not require a building permit. So both of these little chicken coops here, the little greenhouse, there's a picture of it. This wood, they just keep their firewood in here, storage shed, and the small storage shed that's right across. They're all under 200 square feet, and then this would be too, but I don't know. So according to our calculations, there are currently, if we include the dwelling that was proposed, we will have 4 buildings, and that's doing the 3 that we have exempt. If you believe this structure, which we think is a minor structure, accessory structure, that
The movable one.
it's removable,
Yeah.
yeah, I mean, it'll be gone after the wedding. I mean,
Okay.
but if you want to count that as well, we still are under the 5.
Okay.
And I can pass this around. if you
So
want.
Mark, for clarification,
Yes.
Delaware County building permit rules and regulations are separate from Genoa zoning, so any building that has a roof, it doesn't matter if it's, under 200 square feet or if it's, 150 square feet, whatever the square footage is, it still requires a zoning permit,
Unless it's agricultural.
unless you claim agricultural
Yeah,
exemption.
because under law, the township can't require zoning certificate for agricultural. So that would be
So that could be your chicken coops,
the 2
but
chicken coops,
not
the greenhouse,
necessarily
and
the-
this barn that services those, but not necessarily the one wood shelter.
or the
This.
pool gazebo
Well, that was,
I
I mean, I can show you there, it's shown on the spec, I mean, this was added on a long time ago, obviously way before me. You can see the plans are old, but it's shown on there. I mean, if they would do an addition on the house and get that permitted, there wouldn't be an additional permit for just one structure, because it was included.
I mean, I think we got lost in the number of buildings on the.
Yeah, I think I'm more
on the
confused
property.
now.
You're lost?
Yeah,
Okay, all right.
I think I went right there with you.
Let me see, maybe if you.
How many structures are under the 200 limit that you mentioned? So if that does not apply to this situation, then what number does your accessory building go to?
How many are under 200 square feet? Is that what you're-
Correct, because right now you said you have 4.
Either total or under without the agriculture exemption.
Let's do without the agricultural exemption.
Okay, so without the agriculture exemption, you would have 5, and then with the agriculture exemption, you would have 1. The woodshed.
Okay.
Sure. Counsel, is what you're referring to different from what we're looking up here?
No, it's the same exact,
Okay.
it's the same thing we submitted before.
Okay.
My approach, I just, because I understand it's confusing, I just
Oh,
went
yeah.
through this and put pictures of each building, exactly where it is, and then color coded it.
So that's.
Yeah, it's
This
the
is
same,
connected.
I
There's
just
a
copied that.
plus.
They're saying
Right.
this is connected, so
Yes,
that's
it is
one.
connected now.
So the one that's connected is not an accessory building.
4, 5, 6, 7, 8. We got 9,
I'm building,
9 buildings.
right.
And,
This would be number 10, is that right?
right.
Okay.
and
I thought some of these existing were gonna be removed. Is that
Well, I
accurate?
mean, he offered that, he said,
Oh,
you know,
he
I mean, he's
offered it.
building this house, so he wants to do whatever he can to do that, so he said, you know, if there, he can obviously remove the temporary structures, just picking it up
Right,
and moving
and I
it, but
thought
he
that-
also offered to move the, greenhouse and both the chicken coops.
I
if
thought there was a
necessary.
larger structure he was gonna remove and replace it with what he was building. Is that accurate or not?
I mean,
No?
I don't
Okay.
think so, I don't think he needs to if he removes all that, but I mean, the,
Okay, I'm
the
just-
big barn would not be, that would not be able to be removed, it's
Right.
big, but even this little.
I'm looking at the picture, which, yeah. I
The
get it.
barn right here, that's just like a wood shelter, it doesn't have, I mean, it just has.
And
legs
that's
on
not
it.
included in your count, is the wood shelter is separate from the other 5?
No, it's included.
That's included
Yeah.
in the 4 that are
Yeah.
Is that the
considered
wood shelter we're
agriculture?
talking about?
Yeah,
Okay.
yeah. And then the plan is to, I didn't say this before, because I wanted to confirm, but, we have a picture of the barn that he wants to build as a, you know, little guest house, but it would match, yeah, all the other buildings with the brown and the red. Is the plan,
counsel,
yes.
all right. Just tell me, are you guys, is your client claiming this is an agricultural exemption or not?
No.
Okay, so this is,
Because
this is one of your counts.
Yeah, it is one of the counts.
Yeah.
It just
Yeah.
stores wood, and unfortunately, I don't.
Oh, this is all that stores is wood, huh?
Mhm,
Oh, that's not the one I'm looking at.
yeah.
That's this one. Okay.
And the pictures were just so if you had specific questions, you had copies of the pictures.
Oh, we see. Oh, so it's not even enclosed then, is it? It's just
No.
kind of open with 2
Yeah.
big areas. But I also see staff's point as well.
Can you explain to me what these structures are in this
That's
picture?
when you, yeah, sure.
There's, looks like
That's
there's
when you-
something large on the left,
Yeah, if you go, that, right
That-
here.
yes.
Yeah, go right there. Yeah,
back one.
back one, yeah. So when you come down the concrete driveway, this is the storage shed on the left. So that is this building here. And then these are the 2 chicken coops to the right.
Okay.
Oh, those are the chicken coops.
Yeah,
Okay.
like this is the, I don't know if you can
Oh,
see,
right
these are
there.
new pictures I
That's-
took, but,
Yep,
because I took them with the chickens that are here now, but that's from that angle, and then this is from the, so this is behind the chicken coops, and you can see that building. I was on, to the right of the chicken coops.
And you're claiming these are agricultural, not in
Yes.
your count?
They are agricultural, yes.
All three of those, including the one on the
Yes.
left?
Yeah.
What's the one on the left used for?
It just has, I have an interior, it has food for the chickens and the supplies they need to get the eggs, and then you can see it's got wheelbarrows and storage for, you know, taking care of the plants too, because they're plants in the greenhouse too. It's like a little storage. It actually has two horse stalls in it too, but there's not horses there, so. Does anyone want to see this, my art project that I did? My daughter said, is it show and tell? But it does spell
In the
out.
upper left, that is included in your 4?
Yes.
Okay.
Yeah, that is and that's why I apologize, because I was kind of using the gazebo and pool house interchangeable, but you can see
Oh, go ahead.
that it's one unit, and it's on the plans when they did the big addition to the house. I have it color coded too for what the agriculture exemptions. I know it's confusing.
Are these two the same building? This building and this building?
Yes,
Okay.
yeah, they're just two different angles.
Okay.
Thank you. Okay.
Susan, does staff agree that with the proposed building, there would be 5?
Yep.
If you're confused.
Well, one of the issues,
So-
I know that you do tons of these, sorry to interrupt you, but one of the issues before was the carriage house. That was a big issue, because the carriage house was to be considering, one, an accessory building, and two, accessory dwelling. You're only allowed one accessory dwelling, so since we've taken that out, that reduces the number of accessory buildings, one, and then it also reduces it down to just
Okay,
requesting one dwelling.
so one of my things that I'm not quite understanding is on that plot plan, right behind the main part of the house, there's a square.
Yeah.
And then off to the side, there's another one that says pool.
Okay, so let me.
So
show you.
how are those two one?
They're not one.
I
So-
thought I heard you say they were
yeah,
one.
So this is the pool house gazebo, but you can see it actually is a pool house and a gazebo, but this is one structure. It just has the supplies for the pools built in underneath. And then this is the structure that's temporary, that they can move around. That's the one right behind, to the.
So
right
you're
beside-
going to remove the temporary one and
Yeah.
it's no longer gonna ever be there?
No, yeah,
Okay, because we don't consider those temporary.
that's considered a.
Like the board has other cases where people have had to come in and get permission to have a second
Right.
building because they had that
Yeah.
exact same
Yeah, I mean,
thing.
he's planning to remove that after
Okay.
the wedding, but even if, that's why it's a different color, because even if that is included as an accessory, you know, a building, we still, with this, would be at 5.
And then you're saying 4 of the other buildings are agriculture
Correct, the
exempt.
2 chicken coops, the greenhouse, and then this that's storing everything. Yeah.
And that's only being storage for the chickens?
The chickens, they have all their supplies for the, you know, there's a lawnmower, there's chicken food, they have things.
Yeah,
to
one of
get
those
the
is one that
eggs,
moves,
and then
right?
they also
And
have
stop
stuff
calling
for all the plants now.
Okay.
Sorry, I still am a little bit confused, and I think,
Okay.
so this is the gazebo, right?
No,
That's the temporary one.
that is this, the shelter house.
And that's the temporary one that can be moved?
Yes. And then the gazebo is this,
Oh,
that's there.
do we have a
Oh.
picture?
The
I don't think we have a
example
picture of
pool
the
house, because
gazebo
it's got the
for
pool
you.
supply,
No.
you know, the pool, you know, the
Not
things,
that I
and
need it,
that's one.
And that's where I'm getting confused,
Yeah,
okay.
I
The
was
shel-
confused too.
The shelter, the open air shelter is the temporary one that can be removed. The
Correct.
gazebo is part of
Yeah,
the pool
it's shelter
house.
house, and then pool house is permanent, and we're counting that.
And the pool house has a gazebo.
Correct.
So those are one.
Attached, yeah. The pool house is like underneath.
Got it.
We can make the removal of the temporary structure a condition, yes?
Yes.
I would
approval.
suppose so. We can probably do whatever.
So, and when's the wedding?
August 30th.
So by, say, year in 24, give them, what, 4 months?
September 30th, why not a month to get it out?
Okay, hey, if you want to make the motion, you make the motion. I'm not, I'm just one guy here. Okay, any other questions from
Yeah, they treat
the
it as a wedding
applicant? Anyone?
prop and get
All
rid
right,
of it.
let's hear, I thank you, we may come back to you.
Okay.
Thank you, I appreciate the art project.
Oh, yeah.
It's very enlightening.
I was teaching my 6-year-old, this is why you need to.
Oh, boy, they take a lot of work, don't they?
I made it clear, though.
There you go. Okay, any public comment? Please state your name and address for the board.
Rick Whelan, 9500 Britton Woods Drive, Galena. Board, on your section 302 under conditional use permits, it says an application for a conditional use permit by at least one owner of the property is required prior to any authorization by the Board of Zoning Appeals. At a minimum, the application shall contain the following information. I pay your attention to section 302.10. A site plan of the proposed site that I would like you to read and confirm that there is a drainage plan on this application. If not, I contend this application must be denied at this point until you get the proper information. I don't like coming up here and going to hearings when the board is not prepared and not having the proper information that's required under our section of the zoning code. Number 2, let's count the buildings, please. And here's my first question, is on the existing residence. And there seems to be an addition that was put onto that residence, as it says existing garage on the plan. And the attorney here is contending that that is considered all one residence. And I'm contending that it is not. It might be connected, but it's not connected by habitable space. You can't have a building just connected with a breezeway and call it all the same principal structure. If you can, you might have to confer with your attorney and make sure that that's possible, because I don't think it is. And that's part of her contention, calling that one structure. I think that is an accessory dwelling. I believe it has plumbing and stuff in it. I don't know what's in it. I don't know if you guys have done any investigation into it. I wish you would. It's your duty to figure out what's on that property so that you know what you're talking about. You have to understand if that's an existing dwelling. And if it isn't a principal part of the building, it has to be attached, I believe, by habitable space. Not walking outside in a breezeway to another building that was attached as a temporary dwelling structure for some remodeling that they did at the house. Those are two separate structures in my contestants, and I implore you to investigate it. So once again, let me go to the board. I count 1. The pool is 2. The pool house is 3. This existing barn here, and this existing barn. This existing barn is a pretty good size. I would contend that that is an accessory structure, agricultural or not. That would be 4, and here's the other existing barn that is 5. So I come with 5 right there, not counting this existing barn, which looks to be a pretty good accessory structure. So whatever they're claiming for, and these say greenhouse on it, this doesn't say chicken coop on your application. If you're gonna have an application, get the stuff right. The attorney's in here talking about a chicken coop. Your application says greenhouse. So with the new proposed building,
Okay.
that would be
thank you. Your
6 or
time-
7.
Your time has expired. Thank you, Mr. Whelan.
You're welcome.
Thank you.
Okay, any other members of the public wish to speak? Okay, hearing none. Okay, that will close public comment and move on. So. Okay, any members of the board,
I think we have the applicant, give the
I
applicant
can't
a
hear
chance.
you, Bob.
I think we give the applicant a chance to respond to
Do
the
you want to
public.
respond to the, any of that? Pardon? I mean, you don't,
I mean, there's just a lot of statements that aren't, I mean, the chicken coops are they're chicken
let
and
me
greens.
just say,
and-
you can't, it's not necessary, I mean, it's not mandatory you respond,
mean,
but do you,
Yeah,
yeah.
I don't know
Okay.
what the point of that was.
sure.
Yeah.
Okay,
I mean, and we have blueprints showing that, I mean, the application for the carriage house made it clear it was going to be attached to the primary dwelling, which it was, and there's pictures, it's attached, and there's blueprints showing it's all one structure.
I think, didn't we cover that right
Yeah, I
off the
mean,
bat?
Susan mentioned that at first, so.
Yeah, I
just-
think so.
Yeah. And a pool's not an accessory building. He's counting up the pool, that's not an accessory building, and that barn that he says large, it's under 200 square feet. It's got 2 horse stalls in it, so.
Okay. Okay, any questions for the applicant, staff, anything? Anybody want to make a motion? Right.
Yeah.
Oh, right,
on
okay.
30210.
Let's go through the conditional use standards, okay. That's true.
I think that might have been the only right thing.
Good idea.
All right, I'll take a stab at it.
Thank you, Mark.
Okay, section 1713.01. Accessory dwellings shall only be permitted in zoning districts in which they have been expressly authorized within this resolution. Conditional use approval shall be required unless otherwise specified. And I believe that in this particular case, we do have accessory buildings, so they do need a conditional use to build the new building that they're discussing. Any other comment, people? Just please feel free to jump in. Second,
Accessory buildings are a permitted use in an SR district.
accessory buildings are permitted
That
use.
is
Yeah,
true.
that's the first, and then because of that, we still need the conditional use for the new structure, right?
So you're going through to determine whether they meet all of the conditions to be allowed a conditional use.
Right. But to get that, they do need a conditional use, right? To go forward with the new
They have
structure.
to meet all of the conditions listed here.
Right.
correct?
But the end result is that they'll get a conditional use if they meet all those conditions.
Correct.
Yeah, okay, right. Okay, number 2, section 1713.02. Accessory dwellings shall only be established on lots that are 1 acre or greater in size. This is 5 acres? Yes?
Correct.
Okay. Number 3,
What
section.
meets that criteria then?
It satisfies the second criteria. Point number 3, section 1713.03. The number of accessory buildings containing an accessory dwelling shall be limited to 1 per lot. And that's true without a conditional use,
Correct.
correct? And they're seeking the conditional use here.
They
So
have one. right?
as of right now, they have 1 accessory building and 1 accessory dwelling, correct? No.
It's connected, so it's not a dwelling.
They're proposing 1 accessory dwelling in a new accessory building. Currently, they're
Correct, the accessory.
testifying that they do not have any accessory dwellings within an accessory building.
So if we grant the conditional use, they would have 1 accessory building that's an accessory dwelling.
Correct.
And that's point number 3. Point number 4, section 1713.04. only one accessory dwelling shall be permitted within an accessory building. And that goes to the point that we're just discussing. If we grant the conditional use, there will be one accessory building within one accessory.
They testified that the accessory dwelling will occupy the whole entire accessory building, so that will only be one.
Right.
They won't have
That's what
two,
this
like, they
says.
wouldn't put two apartments. They're gonna have one accessory building, it's gonna encompass the whole
The entire
accessory.
building.
Accessory dwelling will encompass the whole accessory building.
Correct. And that's what 1713.04 says, right? All right, and number 5, section 1713.05, an accessory dwelling may comprise up to 100% of an accessory building. And once again, if the conditional use is granted, they'll have an accessory building, and the accessory dwelling will take 100% of that accessory building. Number 6, section 1713.06, the floor area of an accessory dwelling shall not exceed the floor area of the principal dwelling it is accessory to. And as I recall from reading, I believe the application, the principal dwelling is over 5,000 square feet,
Yeah.
correct?
6,822.
And the accessory dwelling itself is under 2,000.
It's 1,366.
Okay, so clearly that satisfies section 1713.05. Point number 6, section 1713.06. Is that the one I just did?
Yes, one you
Yeah, I'm
just
sorry.
did.
Okay, number 7, section 1713.07. Accessory buildings containing an accessory dwelling shall comply with all provisions established in section 1609, as well as all other standards applicable to the zoning district in which it is located. In instances of conflict, the provisions within this section shall prevail. Susan, I guess I would defer to you. At this point, from your review and analysis, would you say that the accessory buildings containing an accessory dwelling are proposed to comply with all provisions of 1609?
My suggestion would be that you go through 1609 and make that determination.
It's funny, I was just going to
I
say
was just gonna
that.
say, why don't we grab 1609 and go through it?
Great minds.
Someone else can do that.
Yeah, sure.
And then some 1601, 1609, 01.
Where does it start? Here we go.
It's on page,
16-2, yeah.
that's on page 16-2 and 16-3.
Okay, it looks like there's 6
6 criteria.
6 criteria, starting with all accessory buildings shall be in conformity, oh, that's the lead-in, with the following provisions. A, no accessory building shall be erected within any required front yard setback of the principal building.
And I don't think we had,
The property.
yeah, I was going to say, I don't think you're.
Mark, I think the
All
picture
of
speaks for itself.
all
Let's go
of
back here.
Everything's behind.
Okay? Side and rear yard setbacks for accessory buildings shall be 10 feet. When the required side yard setback is less than 10 feet, the accessory building may be located at that reduced setback.
Mark, I think that her schematic on the screen shows the setback lines of the and the buildings are within it.
Yeah.
See the side yard setback? And there is not one in the back, so we're talking about side yards here. Side and rear yard setbacks,
She's proposing at 90 feet
from the back,
from the side.
from the side. And there's the back, okay, good, good. Okay, so they're not encroaching upon the setbacks. They aren't, it doesn't appear that they're even close to the setbacks. Point C, the maximum number of permitted accessory buildings per lot shall be 1, plus 1 for each full acre of lot size, but in no case shall exceed 5 accessory buildings on a lot. There's been much discussion tonight about, are there as many as 9? And the applicant is suggesting that with the new building, there would be 5. correct?
Yeah, and there's 5 acres.
Right, so there's
Right.
1 plus the additional 4 acres would make a total of 5. So 5 buildings, I guess that's a point for the board to decide individually whether there are 5 or not.
I would suggest is that if we find that that this will be 5 total on the lot, then it does comply with this section, if that's our finding. If we want to find that there's 4 agriculture and the remainder, then then it should be compliant,
Okay,
if I can do my 5th grade math.
and that will carry us back to point number 7,
Right.
when we get back to deciding that. Okay. D, the maximum height shall not exceed 22 feet on a lot under 3 acres in size. On parcels 3 acres or larger, the maximum height shall not exceed 35 feet. Again, it's represented that this new structure is 22 feet, give or take. Okay, which is certainly under the 35 feet since this property is larger than 3 acres. E, accessory buildings shall be subject to any applicable building and/or lot coverage restrictions within this resolution. Shall be subject to any applicable building and/or lot coverage restrictions within this resolution.
Suburban residential, you're allowed to cover 20% of your lot with buildings and 35% of your lot with impervious surfaces. If that helps you.
I don't think, I'm guessing, but I can't imagine it would be even close to that.
Yeah, I would think the 20% certainly is a non-issue. Impervious will include concrete.
Pool, concrete driveway, all of the, and then it's, the 35% is the total for buildings and impervious surfaces together.
Counsel, have you done a calculation?
I haven't, but looking at it, I don't think we're anywhere close to that. I mean, there's a lot of, I've been there now twice. And then you've got all the space up front too.
Yeah, and then,
Can't imagine you're even close.
I don't think we're even.
Yeah, remotely close.
yeah, I think we can take from the representation
you
on the
take
screen
5.
that,
Yeah, 5 acres times roughly 43,640. You're never going to get close to that.
okay.
All right, then the last point is no accessory building with any district shall contain an accessory dwelling unless such use is permitted as a conditional use within a district. Accessory dwellings, where permitted, shall comply with section 1713.
I think that takes us back
Circular
That takes
reference.
us
where we were.
Back to where we were.
Back to C.
Okay,
So,
we've done an analysis of 1609, and it appears that this application does comply with all 6 points in 1609. Was that 01?
We have O2. Is it only O1 that we have to concern ourselves with?
This is section 1609.
I think the
There's
only
also
real,
an O2.
Oh, there's a B, all right. All right, there is one more section then, section 1609.02, all accessory structures.
You don't have to, we did the one.
Accessory structures,
This
not
is-
buildings.
Okay, so we only need to be concerned with 1609.01.
oh, no. Okay, I think the only real issue, I think we've drilled it down.
Right, it does say, it doesn't limit it to 1609.01, but,
Yeah, I think the only real issue, since now we've gone into discussion, the only real issue that I see for this application is whether or not you accept the applicant's building count.
right, there's a representation that there's 5.
Correct. And I, for one, am willing to accept it. Because acceptance means that it's compliant.
Right.
If you accept that building count. If you do not, then that's a whole nother discussion. So,
Do we have the site plan
Yeah.
that was mentioned? I mean, like with the water gradient and all that stuff that it
oh, the
says?
drainage?
Yeah, the drainage and things.
Yeah, I don't think
Right,
that's-
do you want to speak to that? either staff or
That's a
council.
permit.
Because
Yeah.
that, I think, isn't that beyond the scope of the township?
That section that was referred to in public comment, it
Yes.
says the board may require those types of documents if it's a concern that you have. It's not a requirement. Those are the types of things you are authorized to ask for before granting a conditional use.
And in this case, my opinion, and this is solely my opinion, is that it is a non-event. Because for the most part, predominantly, everything is there. For the most part, this has, I'm not a soil engineer, and I'd be the first one to tell you that, but I would be surprised if there would be any impact on any adjoining properties at all.
I think if we had adjoining property owners coming and saying there's
Right.
drainage issues now, can we
Sure.
make sure that it's not gonna make them worse? That would make sense.
I
But
would agree. We would hear
We've had
from the
none.
adjoining
Yeah.
property
This with
owners.
several neighbors before he even,
Of course.
and no one, I mean,
They
he
didn't
wouldn't.
show up.
Then a
he
sign
even-
out.
Well,
for
even
what?
said if a neighbor said, I don't want you to do it, he wouldn't, but he's been there
And
for a long
there's
time.
been a sign up for what, 90 days now?
Yeah. 120 machines,
Yeah, whatever the number is, yeah.
because we,
So I'm sure there would have been some discussion on that had there been an
It
issue.
goes away
That
and
would be
comes
my
back.
opinion. What's that?
It goes away and comes back.
It returns to the scene, okay.
And this proposed building at its nearest point is 90 feet to the property line.
Right,
And much farther than that to the rear that's a side property, and then much further from the rear property line, so.
Well, and
I-
if you looked at the overhead, there's, at the directly back, it's just an empty space.
yeah, I think it's what, a wooded, well,
pond behind us.
yeah, I was gonna say a wooded area and a retention pond back
Is that what
there,
that
I
is?
think. I think I saw that.
That's
Yeah.
not a concern of mine.
Can we expand on this screen here? Zoom in, that's what I mean, yeah. And drop
I saw it
it
in
down,
this.
I like to see the
There
dwelling,
it is.
not the other way, I'm sorry, in the house, yes.
And you can, just to add to that, you can see the slope. It's, it's,
Nothing, Mr. Chair, nothing in the things that in our township ordinances.
right,
That I see anywhere where the breezeway is defined, what, requiring it to be habitable within our governing rules. And as we've been instructed by our council, that we can consider it. And as I look on here, and then we also were given the picture of
right.
of the actual drawing of how the,
How it's connected.
Those are here too, I can show you.
and then also when we were looking on the picture there, for me, that breezeway satisfies, at least for this numbers
Yeah, it's connected
purposes,
on
to make that one structure.
We talked about that.
Right.
At the original hearing.
And I had to listen, I
Explaining
listened to it,
depth.
I wasn't party for the first one, I
Explaining
listened to it.
Yes.
But after listening to it, I went back and looked, I didn't find any guidance for us to do what the public has requested, that we can consider it. And as I look at this drawing, oh, that's better, it's an actual,
Someday I'm gonna get to sit somewhere where I can see this.
and then when you look at the overhead of that picture, it is more than just a simple breezeway. To me, that's one structure. And if we accept their agricultural use,
Right, and that's why I say,
and
I
I
think,
understand, when the public made the comment, I was confused when it said greenhouse until we got the pictures here
Right.
that
I think
that is the worst greenhouse in the world since there's no windows, no,
Right.
those are chicken coops. So I
it's-
think,
Yeah,
for me, the number, you know,
right, really, for me, the discussion point is the number of structures
Right.
that are on the property.
and I'm satisfied so far with the explanation.
I tend to agree as well. I don't, and a lot of this, obviously, what we do is subjective anyway. And then, I look at conformity to the neighborhood, I look at the use, and it's, for me, the use is contiguous. Where it's, I would consider it one structure. Breezeway, even though it's connected by a breezeway. So, my suspicion is
And actually, if you take a look at it in the drawing, it's a connector
Yeah,
and not necessarily, not a breezeway. So even in the drawing, its purpose was designed to connect the two buildings and make them one.
right,
If you take a look at the
right.
wording
and
on
then
the, even on the
intended to do.
plans itself.
I would agree. Okay. Anything else? Question? No, nothing? Ms. Yu, anything?
Nope.
Mr. Phillips?
I'd like to make a motion.
Okay.
Move to incorporate exhibits A through F. Were there additional exhibits today?
Did you want to include
I can leave
the,
this.
the storyboard?
Okay, G is the,
Tell your daughter thank you.
She didn't help me, she just made fun of me while I was
Are
making
these- Were these numbered as an exhibit, these
I
pictures?
do not believe they
No,
were.
oh, that's right, we've
I
got.
would
the
like these
pictures
actually numbered.
For
For the
new
application?
submittal,
Okay,
so they would be part of,
Would-
I mean,
would
you can make them part of the exhibit again, but we included those as the new revised plans and application, Exhibit E, because we got those all as one packet.
However you think it works best, but many of the pictures in here were instructive for me, so I want to make sure that they're,
Is that the same pictures that are there?
Some of them are, some of them aren't.
Let's
If
do
I
these
went
as
out
a
on.
separate exhibit.
yeah.
like, I would prefer these as G, if we could move these
G
in the, as
13
G.
Sure.
photos, Exhibit G,
I thought it was a.
and the poster board would be H.
Yeah, because I went out after I got your memo back and took
Yeah.
a couple more to clarify things.
Okay, so exhibits A through H, as well as the board's findings pertaining to the review of section 303 and 1713 of the Genoa Township zoning resolution into evidence and to approve the subject conditional use request in accordance with section 303 of the Genoa Township zoning resolution for BZA case 2024-06. Application received April 17, 2024, to allow for an accessory dwelling on property at 4986 Hawthorne Valley Drive, Westerville, Ohio 43082. Zoned suburban residential, that's SR, based on the aforementioned findings. Number one, the proposal complies with all requirements of section 303 of the Genoa Township zoning resolution as documented during this hearing. Number two, the proposal complies with all requirements of section 1713 of the Genoa Township zoning resolution as documented during this hearing. I believe there is a number three.
Mark, I think that's where we put in the removal of a temporary structure, say within 30 days of the wedding.
I was going to do that below, but yeah, we can certainly do that here.
Yeah.
Point number three, the temporary structure / gazebo to be removed after the wedding, which is tentatively scheduled for August 30th, 2024, but in no event later than September 30, 2024. This motion only requires the issuance of a conditional use permit. Such approval is subject to the following: all required permits, zoning or otherwise, be obtained. Number two, pursuant to section 305 of the Genoa Township zoning resolution, the conditional use permit shall expire if for any reason the conditional use shall cease more than 6 months or is not begun within 12 months of the date of this approval motion. Is there a second?
Second.
Okay. Further discussion? Anyone?
No.
I guess I'll call the roll. Mr. Christian?
Yes.
Mr. DeRose?
Yes.
Mr. Phillips?
Yes.
Ms. Yu?
Yes.
The chair votes yes. Motion's carried.
Thank you.
Thank you. Thank you for your patience, by the way. I
Oh,
know-
thank you. Yeah.
Yeah. Okay. And the hearing is concluded at 8:57, or 7:57.
And that was the easy one.
Yeah, because I'm gonna, I have a feeling we're gonna be here a little bit on the next one, so I'm gonna go.
Okay, hang,
to
yeah,
the bathroom
hang on
and-
1 second. And we'll take a 5-minute break if that's okay.
I'll be using the podium probably.
Okay. all
But
right. Just
I'll
take-
carry it with
take
me.
it with you.
All right, thank you.
Okay, we're back in session, and this is our administrative appeal. It is 8:05, and I'll read the legal notice into the record, and then I'll swear all those that are appearing on this matter in. An administrative appeal filed by Rick and Jane Whelan regarding the issuance of zoning permit number 202-4111 for construction of a new single-family residence at 9745 Britton Woods Drive, Galena, 43021, currently zoned rural residential, and that's RR, and this is BZA case 2024-10. Those that are appearing on this matter, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Be seated. Okay, the legal notice for this hearing was printed and published on July 3rd, 2024 in the Delaware Gazette and posted at the Genoa Township Hall on July 1st, 2024. An attempt to mail notice of this hearing to property owners contiguous to and across the street from the subject property was also made. The following are marked in as exhibits A through C: the legal notice, the sign-in sheet, and the administrative appeal filing, which is the application. And we will start, we'll start with the applicant.
Mr. Chairman, a
Yes.
point of order, and I apologize, Mr. Hunt. You will hear during the property owner's presentation that we object to this appeal and believe that this board can dismiss it outright based on a lack of standing.
Okay.
If I may have a continuing objection to their presentation on
Oh.
that basis, then I won't need to keep repeating that and can wait for our presentation.
That could slow things down just a smidge. Your objection is noted.
Thank you.
Counsel, are you saying that you're moving to dismiss based on lack of jurisdiction?
That's correct. If they don't have standing, they can't bring this appeal. The appeal is not properly before this board.
I was gonna say,
think
should
would-
we
I
hear
think
that
we should
first?
hear- That's more or less a 12B sort of
Yeah.
motion. I think that takes precedent.
That's what I'm thinking as well.
I want to hear the arguments on standing, both pro and con,
Yeah.
if you don't mind.
No,
Before we
you
get
know
into
what?
that.
I was thinking the same thing. So if you're objecting to standing,
Yes, I am.
so you're up.
Thinking, counsel, if you limit this part of your remarks just to the standing.
Absolutely.
At this point.
Absolutely. We do have a presentation, which I'll hand out.
Because if there's no standing, it's a superfluous exercise to go through the case. I agree
We're gonna
100%
have to,
with
We
you.
can
we're
both.
gonna have to go to
yeah.
executive and
Correct.
on this. and
Oh,
this
we got
and
one, okay.
And then come back out.
Right.
I would direct your attention to slide 4, if I might.
Is that, okay.
The slide prior to this for just a moment.
Sure.
It will be our position, if we need go forward, that the zoning administrator properly issued the permit at issue, but in the first instance, we think that this appeal should be dismissed or overruled. The permit was issued on May 10th, 2024, and I apologize. At the outset, I should have said, I'm Joe Miller, 52 East Gay Street, on behalf, and I'm joined by my colleague, Liz Alexander, on behalf of property owners Greg and Holly Cush. Greg and Holly, if you could stand or be acknowledged in some way, I appreciate it. And so Dr. and Mrs. Cush applied for this permit, and it was granted correctly, in our view, on May 10th, 2024. An appeal was filed by the Whelans on May 29th, 2024, contending that the permit was issued in violation of a specific code ordinance in the township's zoning resolution. We believe this appeal would fail on 4 independent reasons. I want to focus on the first one listed there, namely that appellants lack standing. If we go to the next slide, entitled Appellants Lack Standing Because They Are Not Adjacent or Contiguous to the Subject Property. Mr. Chairman or another member a moment ago correctly made reference to the fact that you can go into executive session, you can deliberate on this matter of standing, and you'll have the opportunity to confer with counsel, I presume. Counsel can advise you on this, but I think Ohio law, as we've laid it out there, is clear. Mr. Whelan and his spouse lack standing. You cannot pursue an appeal under Ohio law unless you are adjacent or contiguous to the subject property. Here we've itemized just a few of the decisions that make that clear, that it is adjacent or contiguous property owners that have standing to seek appellate review before this board or in the courts, and contiguous landowners are the ones that are directly affected by a zoning decision. And contiguous, it's been further found by the Court of Appeals in Ohio, means sharing an edge or boundary, touching or adjacent. If we look at the next slide, in my opinion, respectfully, this is not a close call. This is the aerial map that's on the screen. You can also, it's the 6th slide before you. Appellant's property, the Whelan's property, is more than 1,500 feet away from the subject property. I want to orient you. If we could look at the next slide. It was up on the screen just a moment ago. Thank you. Yes, this slide. To orient you, 9745 Britton Woods Drive is the green star at the top of the photograph to the north. That is the property owned by Dr. and Mrs. Cush, Greg and Holly, who are here tonight. The appellants, Rick and Jane Whelan, reside at 9500 Britton Woods Drive. As you can see, it's certainly not contiguous, it's not adjacent, nor is it even right nearby, frankly, under any reasonable measure, the Cush residence. I was out there tonight. You can't see this lot. You can barely see it from the contiguous owner's property. You certainly can't see it even from the Whelan's property. The Whelans live over a quarter mile away from this home site. And frankly, I've been involved in appeals where properties much closer had their appeals dismissed for this lack of standing. I would also point out to you in the next slide, if you can't show that you're contiguous or adjacent, you have to somehow show that you are personally aggrieved by the situation, that the zoning decision uniquely affects you and any harm is real. It's not speculative. I submit to you that can't be satisfied by this appeal either. Instead, what we have is, if we look at the next slide, and this goes directly to standing, this question of whether they are directly and uniquely harmed. If you look at the packet that appellants submitted, they clearly realized they couldn't meet the contiguous and adjacent standards, so they itemized what they believed to be some harm if the zoning decision were allowed to stand. And we've itemized them here in this table. If you look at the left side, alleged harm, and you look at the right side is our response. Mr. Whelan stated in his appeal that interfering with the development of a planned T turnaround lane for fire truck access will, in turn, create safety issues. Will. That is the ultimate in future and speculative harm. Not realized, not immediate, and not even unique to him. The fact of the matter is, the future turnaround lane that they reference has not even yet been constructed, and any possible safety issues stemming from that are entirely speculative. I would even commend to you that on site today, and we can show you aerials if you would like, there is still a T turnaround location currently located at the end of this street. It still exists, and so this is the ultimate in future and speculative claimed harm, but not actualized, not unique. In his appeal, Mr. Whelan also generically makes a vague reference to drainage issues. Well, in fact, in that same document, appellants admit that they already have drainage issues that are not caused by this subject property. Any concern about supposed drainage issues in the future is exactly that, speculative. Drainage of the home will be addressed by applicable stormwater controls. In fact, as you know, drainage is thoroughly addressed in final engineering of the home, and this isn't the forum for that, even if that harm were even realized today. It is not. It is completely speculative and fails to satisfy Ohio law as it relates to standing. Finally, the last and only thing that Mr. Wieland itemized in his appeal statement was that, quote, "The value of applicant's property will," note the future tense, "be detrimentally impacted by the proposed development." There was no evidence of that submitted, nothing of any kind, but instead just this itemization. In the future, I think I may have my property value detrimentally impacted. In fact, if that's ever true, he can bring separate actions related to that, but it does not give him standing in this appeal. It does not make him directly, and certainly not even uniquely affected, and we've already seen that he can't claim standing based on his property's location. We do have an appraiser here tonight prepared to testify as to property values. We do have very well-regarded builders in this community, Ron Guzzo and Joe Garner, prepared to testify as to drainage issues, but none of that is necessary. I submit to you that instead, not being contiguous or adjacent, in my opinion, under Ohio law, not even being remotely close to that standard, and not itemizing any harm whatsoever that is actually real and not simply speculative, and certainly not unique to him, there is no standing in this matter, and it can be dismissed on that basis alone. With that, I'm happy to answer any questions of the board.
Questions? Anyone? Pardon? Okay, till after we hear from the applicant. If you would introduce yourself?
Sure. Good evening. My name is Brian Hunt, attorney for the applicants, Jane Wieland and Rick Wieland. To respond to opposing counsel's arguments, being contiguous or adjacent is not the only means by which a party can establish standing in a situation like this. I would direct this board to section 306 of its resolution, which states, in accordance with ORC 519.15, appeals to the Board of Zoning Appeals concerning interpretation or administration of this resolution may be taken by any person aggrieved or by any officer or bureau of the legislative authority of the township affected by any decision of the zoning inspector or an authorized administrative officer enforcing this resolution. So the question is not necessarily whether or not my clients are contiguous or adjacent to this property. I'll admit that under Ohio law, that tends to automatically create standing in most cases as far as the courts are concerned, but rather the question is whether or not they are directly affected by this decision. I disagree that we were required to establish standing with the application. We are prepared to have my client testify tonight as to how he and his wife will be directly affected by this decision and why this appeal is appropriate and standing is conferred in this case. And I would ask the board that we be afforded the opportunity to do so.
Okay. Go ahead, Bob.
I think that this is their time. You know, the question on the floor right now is your standing. So if you have evidence that goes to standing, I would say that you present that at this point.
Okay, I'll limit it just to the standing issue.
Yes, please. This is just to the standing.
Right.
Is it all right at the podium?
Sure.
Thank you. May I approach?
Sure.
Want this to be the presentation, this is just
Thank you.
standing, right?
We have some exhibits that may go to standing.
Okay.
so that's fine. Good evening, Rick. Could you state your name for the record, please?
Rick Wieland,
And what is your address?
9500 Britton Woods Drive.
And is your home located in any type of subdivision or planned community?
Yes, it's in Britton Woods subdivision.
And what is your professional background?
I'm a home improvement contractor
How long have you been doing that type of work?
since 1982.
And what does that work involve?
Everything from changing the kitchen sink to building a complete house.
Would you say that you have extensive knowledge in terms of developing properties?
Very extensive knowledge.
And is that for residential properties?
Strictly residential properties.
Why did you decide to seek an appeal of this zoning permit tonight?
Because I believe that the zoning inspector, Mr. Joe Schaefer, was not correct in his decisions and how he went about offering his application and approving the application for this project here.
And how do you think that this particular zoning permit is going to affect you if it moves forward?
Well, it's more of a procedural thing as far as the zoning permit and stuff, as far as how it's, I believe it's a failure as far as the zoning law, as far as how we're supposed to do this stuff. There's certain requirements on how things are supposed to be done, and I don't believe that's happening in this case. You know, so it's not, there's other things strictly that will affect me as far as a resident in that neighborhood.
Could you talk about those, please?
Well, when we bought into the neighborhood, we paid a premium of approximately $230,000 for these lots. And when we did that, we were assumed that our road, and there was another section called Brittonwood Section 2 that was supposed to be attached to the top of this road, which in turn was supposed to go down to Red Bank Road, which I don't believe has been submitted on. I don't know if we have anything submitted that for the board to look at or not. But what happened was the developer went bankrupt and Section 2 never happened. So we ended with our road stopping where Section 2 was supposed to take off and nothing ever got done. And we have a punch-out list from Delaware County, and the number one thing on that punch-out list was a T-turnaround was supposed to be placed at the end of that road for fire apparatuses. Because at this point, we didn't have Section 2 for any fire trucks to go down and turn around and go back out to Red Bank Road. So there was nowhere for anything to turn around at that area. So what has happened, and that's been over, 4 years now that this has been done? And we've tried talking to the county about it, talked about to the township about it. The county says that they're not responsible for it or whatever at this point because they ran out of money on the bond that they had, and they didn't get the T-turnaround completed in there. So right now, we have garbage trucks from Rumpke that have to turn around in our cul-de-sac area and back down a section of Britton Woods Road to pick up the garbage and stuff at the last residence and stuff down there. There's actually 2 or 3 residents down on that section of the road because they don't have enough room to turn around down there. Opposing counsel mentioned something about a photograph of the T-turnaround down there. I'd like to show, if he has that, we'd like to show it to you guys, but it's more of a gravel area that's been put in there haphazardly. It's not a complete turnaround for a fire truck, apparatus truck. Doesn't meet the sizes at all for any of that type of stuff. There's no base and stuff for it. I've got a lot of complaints from the township as far as trucks backing off the road, damaging the road, getting into the mud, getting stuck, the snowplow had to get pulled out because he backed up in there over the wintertime and got stuck. So township had to pull him out of there. Then you've got the damage to the right-of-way area and stuff where they did pull off the road and stuff that has to get fixed. So those are just maintenance issues and stuff. A lot of the other stuff comes into drainage issues and stuff up at that end of the road now. And this was a particular case because it assumes I believe there's 3 separate parcels up in there. And these parcels were never put together to create one full building site. They were all separated as separate parcels. And what happened was there was an arrangement made by the Cushes with the county commissioners to deed part of their land to the commissioners for a $1 fee in order that land goes into the commissioner's name so that they could apparently get a driveway to their property, which was the furthest lot back. And there's another lot even up closer to that, which they could have put a driveway on, But that lot was never incorporated with the other one as far as they bought the property, but they didn't join the lots. So they're only getting an application for one lot on one parcel. And I believe we've got some stuff in there to talk about on that parcel that on the deed of that parcel that my attorney can talk to as far as stuff. Do you want me to get into that at all now or not?
Getting more into the merits of,
But more as far as my issues are a lot of the stuff, since they put this little temporary road in there, they're back there building the house now. They've got probably a foundation in the ground. I don't know if they've started framing or whatever, so their process is moving on. But they did put a temporary gravel driveway in there. And when they did that, they plowed out the dirt and put their gravel down in there. But I've got photographs and stuff with that. When they did that, they cut the ground and stuff too low. It's a very flat land anyways that they have. So it's holding water, and there's nowhere for the water to drain out to. And we've talked to the township about that, and the township says that they're not responsible for it. So now we have to deal with the water issues and stuff up in there,
if I could
which,
stop you, because
Go ahead.
you're pointing to an exhibit. If we could turn to those, please. Are you looking at Exhibit 1 right now?
Exhibit 1 is a pretty much a outline of the parcel that's owned by the commissioners.
Okay, and you've circled that, is that correct?
Yeah, I've got it highlighted there as far as little red area and stuff on the small parcel.
And you circled it and it says concern?
It says concern at that area, yeah.
What is your concern about that area?
Concern at that area is that the builder of the property has placed 2 6x6 posts with a chain across it on the commissioner's land.
I would object to further inquiry on this. He was asked, or supposed to be asked, how does this directly affect him? He's gone well beyond that. In fact, the only thing he's described are things that affect residents generally, if at all. It frankly makes the point that he does not have
Adjacent
standing to
to
pursue
Britton
this appeal.
Woods development, which is where he lives. So anything that really affects that development of a whole affects his interest in that development.
But not uniquely, and therefore lacks standing.
My question to you is that what is specific to Mr. Whelan's enjoyment of his property? Because he's not here on behalf of some sort of association, some sort of group, is he? Is that what you're claiming?
No, he's a member of this
He's here for
association.
himself, correct?
Correct.
Okay, so please limit your remarks to what affects his issues.
And that's what we're trying to get
Right
to.
now, I see opposition to the application. I don't see any part where he's agreed. So if you will stick to, and if there's nothing further, that's fine, but I want to know what he's aggrieved for, not just opposed. Those are two different things. I want to know he's aggrieved for what the grant of that permit and the building of that structure, how that affects his property that he owns.
Well, I would contend it's not so much the property that I own. I ride my bicycle and stuff. I walk with my wife and stuff down the end of the street, and that's in our neighborhood. That's in our subdivision.
Counsel, do you have anything further as to what he specifically aggrieved as the property owner as to his property?
Yes. So we've previously said that you believe that your property value would be adversely affected, correct?
I do,
And
yes.
what is the basis for that?
Well, the basis for that is just because of the state of the idea that there's no road or anything put down there for this house to come off of. They have everybody in our neighborhood has concrete driveways. We have beautiful houses, that type of business and stuff. And they're not gonna have a concrete driveway coming down to this road section. This will probably be just a little gravel driveway off the end of the road without any type of structure or anything at that end of that. They don't even own this parcel is the problem. See, this is
You have
the commissioners.
empirical evidence that you can provide that will show a difference in value between now and when they build their property.
How could I? That's in the
I'm
future. I
just
don't know if I
asking the
can.
question.
If I may, Ohio does
I'm
recognize.
going with your contention that it's gonna impact the value of your property. Do you have any empirical evidence that you can provide that it will?
Well,
I would also ask, do you have empirical evidence that they don't intend to make a concrete driveway?
I don't know that. I haven't seen their application on
So,
their
Okay.
stuff or whatever.
But the
so-
application, as it's been approved as of now, there's only a gravel driveway. And to respond to your inquiry, I just mentioned that Ohio has what's called the owner opinion rule. And a lot of times you see it in tax cases. But basically what it is that Ohio views owners of real property as basically having such knowledge of that property that they can testify as to the value of their property, even if they're not a real estate professional.
That is not true. That has been established in real estate tax and eminent domain matters only, and there has been no specific quantification as to value in any event here. It has never been allowed to justify a standing of someone who lives a quarter mile away of why they should be able to bring an appeal.
I disagree with that. I believe that it can be used to, anybody can testify as to how a particular,
If we accept your interpretation of that, just let's accept that for argument's sake right now. Please answer the chair's question. What is the empirical evidence you're showing to that where there has been an actual diminution of value?
well, again, that's the basis behind the owner opinion rule, is that an owner of real estate has such intimate knowledge of their property that they, without some other outside empirical knowledge, can make a determination on whether a particular,
So the reliance, your application is relying upon your client's estimation of his own value and diminished value.
in part, yes, it's,
Okay, in part, what other empirical evidence, other than your client's opinion, are you relying upon?
none at this stage.
Counsel, I would even ask what is his opinion of the diminution in value? I mean, is he going to say it's 0 or 100,000 or, I mean, what?
A percentage,
You
10%,
you said his own
5%?
determination, and I just wonder what his determination is for
Right.
purposes of this hearing.
Well, if I look at my value today on my house, I think they said there's some auditors and stuff here or whatever. You can pull up the auditor site and stuff. My value on my house is around $800,000. The other houses in our neighborhood are valued at about $1.5 million. So why is my house valued so low compared to those houses?
Was construction already started when they did that valuation?
Which
That it
value?
went to 800,000?
Sure, it was completed. Construction was completed for
house.
that.
Yeah,
Yeah.
on their house. Was their
On their
house
house.
started, the
Their
construction
house has
started?
not been built yet, so they have no value on their house at this
So
point.
it hasn't adversely affected your value yet either. Is that what you're saying?
I don't know if it, not at this point it hasn't. You know, I'm not talking about the house causing the problem. I'm talking about the idea that the process wasn't followed correctly to allow for the house. I have no objection to them building their house back there. My objection is to why the stuff was done through the administration stuff as far as issuing the zoning permit and stuff for the house, when the deed and stuff says there shouldn't be a house built on that parcel. And on how they, normally you're supposed to have a CAD and stuff to go back to these landlocked lots. And those were the issues, that I'm trying to
Again, this
address
goes to the
here.
merits, and I'll move to strike or object.
I agree, Mr. Miller.
Counsel, do you have anything else on standing?
Yeah, I think I'd just like to explore a couple more things. Mr. Whelan, did you, when you purchased your lot, contribute any payment towards the construction of Britton Woods Drive?
I'm assuming we did in our lot price. All of us did. That's how the developer came up with the prices of the land. He had to figure up how much he had in that development and divide it up into his lot prices in order to make a profit on it. So all of us paid for those roads, for the stormwater stuff, everything for that development in our land prices.
Is that a private road?
No, it is not.
It's a public access road.
It's a public road and it's maintained by the township at this time. It was developed through the county. The county is the one that did all the inspections on it.
Finally, what I'd like to do is direct you to Exhibits 2, 3, and 4. And could you tell us what those are and how those are affecting you?
Exhibit 2 is a picture from the end of Britton Woods Drive on the pavement, looking north on the Cush's property, actually on the commissioner's property, not the Cush's property, where you can see a chain hanging across there, but the photo was more for the water lane there that was after a couple rains. This was a very nice day. It probably rained about 3 or 4 days before this stuff, and the ground is low, and that's a picture of just the water and how it can drain out of there. So we have to deal with mosquitoes and that type of stuff because nothing can drain out of that area.
Counsel? This is, here you're representing that we're looking at the land owned by the commission?
That's correct.
That's correct.
So
Did you
this
take these
isn't owned
photographs?
by the permit owner?
I'm sorry?
This isn't land that's connected or, excuse me, this isn't the land owned by the permit owner.
No, but it is pertinent because it's the land by which they're crossing in order to get to the permit holder.
All right, I just want to establish for the record, this is the county's land that he was referring to.
I believe so.
Yes, it is. Yes, it is. Exhibit 3 is the same pretty much picture, probably 3 or 4 days later, once the stuff starts drying out in that area. And then Exhibit 4 is another picture where you can see the pavement and the so-called gravel on the left side to where they say that might be some type of a turnaround.
And then if we could look at exhibits 5 and 6, please. Explain what those are.
Exhibit 5 is a copy of the Delaware County Engineers punch-out list with a specific thing noted on number 1 for the proposed T-turnaround for Britton Woods Drive.
What are your concerns if that T turnaround is not installed?
Well, my concern is more of a safety issue and stuff. We've talked to the fire chief and stuff about it, for them to be able to get fire equipment and stuff and turned around there without getting stuck or something in the mud in the ditch. It's a safety issue. Same with the garbage trucks and stuff backing down the ditch. The school buses can't pick up the kids down there.
I don't think that.
So it's more of a safety issue on the T turnaround.
I don't think that addresses the standing issue, which is really the issue that's on the table.
Well, is that a safety issue for you particularly?
Well, it is a safety issue for me particularly because we walk up and down the road and that type of stuff. We don't want to have a garbage truck backing up when we're walking our dog and stuff down the road because he can't go down and turn around at the end of the road. We have to worry about a truck backing up when we're walking towards that vehicle and stuff. How's he going to see us? And it does affect us because I live right in that neighborhood. That's where I'd say I'd have standing in this, not necessarily because I'm adjacent to the property or whatever and stuff. I have standing because that is part of my development and stuff. And we're on a dead-end street. That's why we moved to that area, so we'd have some areas where we could walk around without the traffic and that type of business and stuff, so.
When is construction scheduled to start on the turnaround, the T turnaround?
It never is. It was supposed to have been done by this punch-out list back on this date, I believe.
This has been done by the county.
This is from Delaware County Engineers. This is Exhibit 5,
How
correct?
does that impact the homeowner or the homeowner that's applying for a permit? How do you draw the nexus between those two?
Because the nexus would be, we'd ask if the county would have got involved and had the T turnaround done when the commissioners bought the land. Ideally, if they would have bought the land and
I
had.
understand that. What I'm asking to you, because we're here on your appeal to this homeowner's permit, and I want to know the nexus of how the county's non-construction of a T-turn.
That is for standing, that's not for the permit.
No, but what I'm saying is, how is that connected to the permit that was issued to this homeowner?
It's adjacent to it. Their permit's adjacent to this property.
Rick, is it your understanding that there's an agreement between the county and the Cushes that the Cushes can use this property, the county property, to access their land?
I believe there is.
Do you have any,
Permit for which no appeal was ever taken.
But it's relevant to the question, because if that's the case, then that affects why the T turnaround has not been built.
that's not before us, Council.
Correct.
That's the permit that's before us is the permit for the use of vacant land and the building of a house. And whether your client's aggrieved by a prior permit that was not appealed, you can't bootstrap standing.
Well, I think it's all taken together, because without the agreement
We
between.
don't, but we don't have are you asking us to go back and look at a non-appealed application to find your standing?
No, I'm asking you to see that this application, well, I should say the permit that is allowing for the construction of this home is contingent upon this Delaware County property allowing the homeowner to cross. They're not going to be able to build the T turnaround in that case, which is what leads to the safety issues that my client is talking about.
I'm not debating you that point, but what I'm saying to you here is, on this application that your client appealed, how is whether that T-turn is built or not by the county, how is that impacted? How does this impact the current application that you objected to?
Because the application that we're objecting to, again, with this agreement to cross the Delaware County property are basically one and the same. They're taken together, is
They're
our
not,
understanding.
But
I mean, I know that
But-
you're saying that
but-
there's
but
been a
counsel, hold
prior
on.
permit.
Let's just stop for a second. I'm going to tell you that you won't convince me that they're two same applications. They are two distinct applications. So if that's the sum total of your argument, for me, the question is closed. Obviously, the rest of the members can vote on, unless you show me a way that you can, there's a nexus between a previously granted non-appealed permit on the county property has some bearing or some nexus to a permit that was granted in May of 2024, then I don't see your standing.
And I guess we respectfully disagree with each other, because in my eyes, the permit that was granted in May of 2024 was granted in large part because of the permit that was granted across the Delaware County property.
Okay, even if we accept that as true, we don't have that first application before us. And as I understand the procedural history on that, your ability to object to that permit is closed, correct?
I'm not sure that that permit even could have ever been
Okay.
appealed in the first place.
Okay, so we agree that there's nothing potentially that you can do for that first application, correct?
There was no first application.
Counsel, I'm addressing your counsel, correct?
Well, no, actually, I'm not sure what the first application was. I think that
Okay.
might have been an agreement between, rather than a permit, there was some sort of
So
agreement.
it seems to me that your clients agreed that the first application was granted and are trying to bootstrap a way to undo the first application or agreement, whatever you call it, by appealing this application. Am I wrong?
Yeah, I think I disagree with that for the same reasons I said earlier, is that the.
Okay, then how is he personally aggrieved in the use of his land by the application that was granted?
And it's not necessarily limited just to the use of his land. It's the enjoyment, it's the safety, everything that comes with living in this community. And I think that's what my client is trying to speak to, is that this application is creating hindrances to his enjoyment of the community.
Even if
and we're
true,
getting
enjoyment of the
cyclical.
community is a right enjoyed by all citizens and not unique to
Counsel, I
him.
got that.
I would disagree with that, because we're not talking about a public space, we're talking about.
I want to stay with the safety concern that you have raised is dealing with whether or not the county will do the T at the top of that road, correct? That's the safety issue. That's what I've heard about.
Part of it, yes.
Okay. And the road that I looked at that had the water was also on the county land, correct?
Yes.
Okay. What have you shown this board? Take away everything that has to do with that property owned by the county. What on the property where the permit was granted is aggrieving your client? And nothing to do with that county property, because that application is not before us.
Well, again, I would concede that nothing on the property itself is probably grieving, but it's the entire situation that it's creating through this permit that's been granted.
So the structure of your client's argument is predicated upon whether the first application is proper.
No, I mean, no, it's,
Then how do you get, you've already conceded that nothing on the land that's for this application is aggrieving your client. How do you get there then?
because this application will affect the development of the T-turnaround, correct, Rick?
It could, yes, it definitely could.
And where's your empirical evidence that it impacted? Thank you. What is your empirical evidence that the granting of this permit and the building of this house will prevent the construction of the T-turn that the county's already informed you that it ran out of bond money for, and they decided that they don't have the funds for? So tell me what evidence you're relying upon, and I'm not trying to argue with you, but we need evidence other than opinion. So tell me what evidence you have to say that that is what's causing or will cause the T-turn not to be developed.
The development of the T turnaround would be based not on my opinion of the stuff, but would probably have to be based more upon an a movement by the whole homeowners association to address the county, to say, hey, county, you guys had this stuff in your drawings, you never did it, It should have been done. It still hasn't been done. And when is it gonna get done? The feedback we get from the county is, we're gonna leave it up to the next developer. But you ask what's your empirical value for that? That development may never, ever happen. So in the meantime, we're still sitting there aggrieved because there's no turnaround.
But your issue's with the county, sir, isn't it?
Right.
My issue is with I am aggrieved by the zoning officer's issuance of that driveway going through there because that's why I'm aggrieved.
Chairman, I've heard enough for myself. I'm done questioning.
Do you have anything else that you'd like to add in terms of how this will directly affect you?
Well, like I said, it affects me as far as the enjoyment of my road and stuff, that type of business up in there. I'm aggrieved by the mosquitoes and stuff from the ponding of the water, the no drainage and that type of issues that were never addressed and stuff on it.
Okay.
Anything?
Do I have anything else? Mark, Christian, or Jared? I would. I absolutely would.
Briefly respond.
That's what I
Really
was,
just for
that's
the
where I was
record.
headed. Go ahead, Mr.
Really
Miller.
just for the record.
Sure.
You know, I haven't heard that this gentleman is a civil engineer. I haven't heard that he's a hydrologist. I haven't heard that he's a real estate appraiser. In fact, what I have heard him tell you is his complaints are, quote, procedural. And the quote I wrote down from Mr. Whelan was, this is, quote, not so much about my property I own. That's the essence of standing. The T turnaround, it's on a public road. It's for all residents, not even just of this subdivision, but all residents of the township and beyond. The T turnaround is correctly not a requirement of the zoning permit. In fact, their own Exhibit 5 shows that it was an agreement between the county and his developer. That is with whom this person has problems, the county or his developer. And in fact, Britton Wood residents, Craigan's Court residents, all alike, if there are any drainage turnaround property value issues, none of them are unique to Mr. Whelan. In fact, if we could look at slide number 7 from my presentation, where council began was quoting to you your own code. All he did was restate what I told you, that the only person that can take appeal is someone who is aggrieved. And slide 7 shows you, okay, if you don't live contiguous or adjacent, you're only aggrieved if you have unique and special harm. So the township code just reflects Ohio law. And I apologize as you go into, I apologize as you go into deliberations if I've seemed impertinent or impatient at times. My clients, Greg and Holly Cush, are good people, and they never should have been put to this. If this person has a beef with the county, if this person has a beef with their prior developer, they shouldn't drag these people before you, and certainly, hopefully not beyond, into court. So I hope that you will dismiss this appeal for his clear lack of standing under Ohio law. Thank you.
Okay. I think at this point, we're going to go into deliberations. I'll make a motion that we adjourn for deliberations at, let's see, 7:47.
8:47.
Oh, 8:40.
Yep, absolutely.
Oh, okay, and we're back. It is 9 o'clock straight up. Okay, we have deliberated and I.
Excuse me.
Yes, I'm sorry.
Motion to go back into
Oh,
session.
that's right. We did make a motion to
Oh,
come back.
do you not have to? Oh.
No.
Mark-
Not on
Mark says you
deliberation.
don't have to.
All
Okay.
right.
Thank you.
Okay,
Sorry.
yeah, I saw in the rules of procedure, it talks about that, but,
Mr. Chair?
okay.
Mr. Chair?
Yes, Mr. Wood,
I-
yes. go
I
ahead.
would like to make a motion on the issue of standing.
Yes. Proceed, Mr. DeRose.
I make a motion that the application for appeal to the permit granted under BZA 2024-10 be denied as the applicant's interest is not immediate and pecuniary, appellates have not demonstrated a present interest in the issuance of the permit, and all other evidence of harm and aggrievement is remote and speculative. Going through the case law on this, the applicant is not adjacent nor contiguous to the property granted in the permit. Further, the applicant lacks standing because the harms that have been identified on this record do not directly impact the applicant and the applicant has not demonstrated that they are uniquely harmed. The applicant has testified that his objection is more founded on a previous application and other property issues having nothing to do with the application at hand. Thus, I move to deny the appeal and uphold the zoning inspector's decision.
Okay, I will second your motion. Any discussion?
The
Go for-
only discussion I have,
Yes, go ahead,
Mr. Chair, is that if we, my problem is that we are given, as a quasi-judicial body, the ability to sit in judgment of an appeal of an application only if we, one, have standing, and lacking standing, we can't do anything further on this application and must deny it.
Any other comments? Anything? We have a motion and a second. No further discussion. I'll call the roll. Mr. Christian?
Yes.
Mr. DeRose?
Yes.
Mr. Phillips?
Yes.
Ms. Yu?
Yes.
Chair votes yes. The motion is carried. And the hearing has concluded.
Thank you.
Okay. We have no other business that I'm aware of. And I have a motion to adjourn. Do I hear a second? Mr. Christian? And if you guys could give us a second, thank you. All in favor of adjournment?
Aye.
Aye.
Any opposed? We're adjourned.